issues, whether the management corporation's right, the MC, to collect payment from a proprietor under the Strata Management Act 2013 gave it a lawful preference as a secured creditor over the assets of a company in liquidation. These are the facts. The appellant, a company in liquidation, owned a unit in a building managed by the respondent, the MC. The liquidators required the transfer of the unit into the company's name, but the transfer was refused by Stevens Properties SDN BHD, the developer of the building, unless the company obtained a clearance letter from the MC for an outstanding sum. The company denied the claim, and negotiations failed. The company filed a claim seeking an order that Stevens execute the transfer without imposing any fees, and the MC issued the clearance letter upon the company's payment of a sum. The MC filed a counterclaim and sought leave to commence or proceed with its counterclaim in the Strata Management Tribunal. The High Court refused the MC's application, but the Court of Appeal reversed the decision, allowing the MC to proceed with the counterclaim. The decision, allowing the appeal. The Companies Act, CA, 1965 and the Companies Act 2016 both provide a regime for insolvency and priority of payments to secured and unsecured creditors in liquidation. Section 292 of the CA 1965 and Section 527 of the CA 2016 set out the priority regime for payments to unsecured creditors. The court considered whether Section 77 of the Strata Management Act 2013 dislodged the priority regime in the CA 1965 or elevated the payment of management fees to the status of a secured debt. The court found that Section 77 did not dislodge the statutory priority regime and did not elevate the payment of management fees to the status of a secured debt. The use of the term guarantee in Section 77 denoted a statutory obligation between the management corporation and the parcel proprietor, which was a right in personam, and did not give the management corporation a lawful preference as a secured creditor over the assets of a company in liquidation. The court concluded that Section 77 of the Strata Management Act did not displace any part of the statutory insolvency regime, and was only intended to provide a fail-safe method of recovering management fees as an undisputed debt from parcel proprietors at the behest of the MC. The outstanding sum payable to the MC was not a secured debt, but a guaranteed debt, and had no effect on the rights of third-party creditors. The MC was an unsecured creditor, and any interpretation seeking to accord the debt priority on a parity akin to a secured debt was a miscomprehension of both the effect of the section and the statutory insolvency regime. The secondary issue in the case was whether the MC needed leave to recover the debt owed to it by the company, or whether it was sufficient to file a proof of debt form in the winding-up court. The use of the word guaranteed in the SMA ensured straightforward recovery of the debt, and the issue that remained was limitation. This issue was not complex and could be resolved without adjudication in a court of law. Therefore, there was no exceptional issue in the case that precluded the MC from filing a proof of debt form in the winding-up court, and there was no necessity for the grant of leave. To know more,